Welcome to the Planning Podcast. I'm Richard Kimblin. I'm joined today by Odette Chalaby and Sioned Davies, both barristers in the Planning and Environmental Group at Number 5 Chambers, and we're going to tackle Finch, aren't we?
Yes, we are.
So off we go. I will just outline very briefly where we are for those who haven't been following this case for the years that it's been watched and anticipated. It's concerned with oil. Maybe oil exploration and exploitation is not something that daily comes across your desk. Nevertheless, you need to know about this because it's on the topic of environmental impact assessment, and particularly in respect of what are referred to as Scope 3 emissions, those emissions of greenhouse gases, which are potentially attributable to what happens to that which the project produces further down the line. And in this context, we're at the most extreme and clear scenario in that the question is, when the oil comes out of the ground and, as everybody agrees, is inevitably burnt, is it necessary in EIA terms to take account of, to assess and then to take account of in the decision-making process, the GHGs that would be produced when the oil is inevitably burnt? When you get into that question, there's all sorts of subsidiary questions which the courts have been tangling with. We now have to understand what the present position is, the Supreme Court having reversed the Court of Appeal, and try and interpolate and have a look at what the impact might be for development other than oil exploration and exploitation, whether that is development which is producing something which is to be used elsewhere, or whether it's built development. Are the considerations the same? Those are the sorts of things we need to probe and see if we can help listeners with. And in that regard, having identified what the difficult questions are, I'm going to turn to Odette. Hi, Odette. How are you doing?
Hi, Richard. I'm good, thank you.
So, what do you say, Odette?
Well, I think the first obvious question, as you say, is who might potentially be affected by this? And I think the key point to make at the outset, and this is quite a straightforward one, but it's simply only going to apply this judgment to major development that requires EIA at all. And that obviously cuts nearly everything out because most developments are simply not EIA development. I think the second point is that what it will obviously apply to are EIA developments with analogous downstream effects to the oil in Finch. So where you're producing something, as you say, to be used elsewhere. So that could be minerals, aggregates, were talked about in the judgment, waste, some sorts of manufacturing potentially. So those are the sort of most obvious candidates where this judgment could immediately have an effect on what you're doing in your EIA. I think the third question is whether this judgment has any import for sort of what most EIA development is, which is built development. And the Supreme Court didn't say anything specific about that in the judgment. But I think what this certainly will do is draw more attention to downstream impacts in other sectors. And if you are working on EIA built development, I think it is worth thinking quite hard about whether there are downstream carbon effects that should be captured that aren't being currently. So one example is, many of you will have heard of the Boswell cases in the Court of Appeal, where there you're capturing the downstream carbon effects of the roads when they're used in the EIA for the roads themselves. There might be similar types of impacts in housing, but I don't think this judgment says something specific about it, but it's worth thinking about it, in my view.
So that already starts to sift the impact of the judgment, and thank you for that. Can I turn then to Sioned on the topic of, we can sort of develop that a bit further from the who, etc., into the when, and see if we can tease out a bit further when we might find Finch really having an impact. What do you think?
Yes, Richard. Well, I think firstly, it will only apply to schemes where the impacts are known. So you need a certain amount of information in order to factor in the considerations which Finch grapples with into the EIA. First thing is where the impacts are known. And I think the court were at pains really to point out that conjecture and speculation have no place in the EIA process. Secondly, where the impacts are quantifiable, so where you're able to put a number to the impacts. And thirdly, and perhaps most obviously, where the impacts are likely to be significant. They're not asking for the impossible, and only really to assess if the impacts are capable of meaningful assessment.
That's such an important point, isn't it? In EIA, we're only ever interested, firstly, in likely significant effects, hence scoping, and the directive and the regulations, the assimilated EU law we have, is very clear that one has to do what is possible. The obligation is to carry out reasonable assessment, not to present to a developer a task which is not possible to do, not least because the outcome of that isn't going to be very useful to the decision maker. So thank you very much for flagging the art of the possible. Odette, do you want to add anything to that?
Yeah, so you've got to do what is practical and just simply try your best with the experts you have to assess the downstream impacts. And as Sioned said, it's not asking for the impossible, only do that which is reasonable and try to paint a picture of what the indirect effects would be. And that's really all you can do in the circumstances if you think this judgment's going to apply to your scheme.
Inherent in what you say there is don't try and dodge it, because that's where the legal error comes in. If something which is an environmental effect isn't assessed per Finch, then you could end up with the consent being quashed, which is inconvenient to all of those who've been working so hard to prepare the EIA and to those who've made the decision on it. So have the best go at it you possibly can, but don't try and duck it.
Grapple with it as effectively as you can.
And I think it's important to say, isn't it, that there is a methodology out there for how Scope 3 emissions are to be assessed. There's a framework and a methodology to be followed. So it's not asking you to assess something which is impossible to assess.
So you're right, aren't you, Sioned, that the assessment of Scope 3 emissions has been something that's been around and spoken about and thought about for some time. So in some ways, it's surprising that this fight ever had to be had. I wonder if at this point I might turn to just think about what happens next in the process once you have the assessment which tells you what the Scope 3 emissions are. We're, of course, just to make the perhaps obvious point, we're not in territory here where the Supreme Court is saying if you identify Scope 3 emissions of a certain level or type, that tells you what the decision should be. Rather, the Supreme Court is drawing attention to the underlying requirements, the public participation requirements, which come from the EIA directive in the first instance, incorporating the Aarhus Convention on Public Participation. The whole idea is that the public has an opportunity to understand what the effects are and contribute to the environmental information. And so the decision maker has got all of that information when they come to make the decision, but still it's a decision for the decision maker guided by whatever policy framework is in place. And if one takes the oil example, that policy position may be fairly rapidly changing. And so the decision on the basis of the same information might be different from one year to the next, depending on how the UK's energy policy is positioned. Well, it does strike me as very important to appreciate in respect of this decision. It doesn't tell you what this judgment doesn't tell you what the outcome is going to be. That still remains a question for properly understanding the policy framework, applying that policy and the relevant facts, and then coming to the usual planning judgment. This further point strikes me as particularly important to keep in mind, is that for some forms of development, one is going to have these Scope 3 impacts of a similar order of magnitude, whichever particular development comes forward. And one can see a situation where the assessment is done and the decision maker is left in a position where whether the proposal at site A or at site B were to go ahead, the Scope 3 emissions would be rather similar. And so I have in mind this sort of idea of netting off. When one nets off what the Scope 3 emissions would be, as between a development in one location or by one developer as against another, one is left then to say, doesn't this come down to assessment of what the policy position is in respect of the need for the development and its impacts? And it's not really going to distinguish between developments A, B, C, etc. Do you think that I've got that at least part right?
I mean, I think one question there is, if you have sort of 3 schemes with 3 similar sets of downstream impacts, then obviously that is going to net off in some way, and there won't be a competitive advantage to, say, one aggregate scheme over another. But I think what there could be a difference is in a setup where you can provide mitigation for these effects in some ways. So we're not sure how this is going to apply to housing, but if you had one housing scheme where carbon mitigation was really built in through proper insulation, through solar energy, and another one where it wasn't, then you could get 2 quite different results with a competitive advantage for the scheme that had built in the appropriate maximum mitigation. And that will work in some sectors, it won't work in the oil sector. And that was part of this whole case. There really wasn't any mitigation that could be provided. But so long as everyone is providing the appropriate maximum mitigation, then yes, you would think that probably similar schemes are going to come up with a similar net result at the end of the day.
And so maybe in environmental terms, that's one of the benefits of the judgment. It tends to promote design thought into the mitigation of the GHG impacts. And one might therefore expect better schemes to come forward as a result, because after one has done the assessment, one turns in EIA terms to mitigation. And that's your point, isn't it?
Yeah, that's the point.
That's the point. Okay. What about what happens next? What do we think? Do we think that's it? Do we think we all travel the country carrying a copy of Finch in our dossier of key cases and that's all we ever need? Or do we think that there might be something else happening down the line?
Okay, yeah, thank you, Richard. Well, I think that it will mean that we have to think about the impacts of greenhouse gases more carefully in planning decision making where Finch is engaged. It might mean that it also has caught the eye of policymakers who may be considering more carefully what this means for decision taking, not just in relation to oil, but to other sectors too.
I was just going to say, I agree with you, Sioned, that this will have caught the eye of policymakers, and I think it would be a very good idea because it could certainly save a lot of people a lot of complexity, delay, uncertainty if government got to grips with this and did give some guidance as to how people should follow this judgment in different types of development.
Well, let's keep our eyes peeled on the ever-changing NPPG, and maybe at midnight one day up will pop some guidance to help at all. That's fantastic. Thank you very much, both of you, for educating me on this very long judgment and bringing some clarity to where it takes us in these big questions. Really appreciate it, as will listeners. Thank you very much. That was the Planning Podcast from Number 5 Chambers. We'll be back next time with some more interesting judgments from both the Court of Appeal and the Planning Court, both of whom have been very busy lately. Until then, goodbye.